Good afternoon, everyone. My name is Kathleen O'Hara, and I am a partner with Strigberger Brown Armstrong. My focus is primarily on fraud, and I do work in accident benefits, property PD claims, as well as property claims. Strigberger Brown Armstrong has offices in Toronto, Waterloo, and London to be able to best serve our clients. Just to let you know, if you have any questions during the presentation, please feel free to put them in the Q&A chat box, and I will deal with all questions at the end. We will be recording this presentation, so if you know of any colleagues that might find this of interest, we do post them on our website, so feel free to recommend or send your colleagues there. And just a final note, I can send you the slides at the end of the presentation, so no need to furiously take any notes down. If you want a copy of the slides, just shoot me an email. All right, so let's get into it. Section 53 and willful misrepresentation under the SABS. I wanted to start off with just putting up the wording of the section. There are several key parts to Section 53 that we're going to discuss and analyze today. The important points of the section are that the insured has to have willfully misrepresented material facts, and they have to do with the application for a benefit. The final point, which is not going to be the focus of the presentation, is that if the insurer wants to apply the section, they need to provide notice with reasons for the termination. So misrepresentation, it's surely an impressive sounding word, but what does it really mean? I've thrown up the dictionary definition of misrepresentation for everyone. Here it is. I think we all sort of get the vibe of the term, but lucky for us, the tribunal has accepted and repeatedly quoted a particular definition, which I will throw up here. So the LAT definition is any manifestation by words or other conduct by one person to another that, under the circumstances, amounts to an assertion not in accordance with the facts. This definition is actually taken from Black's Law Dictionary, the dictionary definition of misrepresentation. And the definition was first cited in the Fisco case of Michalowski, which we will discuss a bit later. One issue that often comes up with a willful misrepresentation in Section 53 is whether an insured's silence constitutes a willful misrepresentation. The connotation with the term willful is that the insured has been deceitful or said something that is not truthful. There is case law at the tribunal and at Fisco, which accepts that an insured's silence may constitute willful misrepresentation. So I'm going to take you back a bit to the history of the section. It was first introduced in the 1996 Statutory Accident Benefit Schedule, and the first case to deal with the willful misrepresentation section is the Michalowski decision. This permitted the insurer to terminate benefits on the basis of the insured's willful misrepresentation, but the onus was on the insurer to prove that the insured made the misrepresentation, that the misrepresentation was willful, and that what was misrepresented was material facts respecting the application for benefits. The Michalowski case has been followed and referenced in many other subsequent decisions, both at Fisco and at the LAT. There were some other key takeaways from the Michalowski decision, which are helpful for analyzing whether or not you can apply the section. The adjudicator cited that the misrepresentation is not limited to having to have been made on the application forms. This is the first case that said that silence may amount to a misrepresentation. The term willful was found to mean deliberate or intentional action. And there was comment that the facts misrepresented must not merely be important, but actually had to be sufficiently basic or fundamental for the relief submitted to be available. Whether or not the misrepresentation relates to material facts would depend on the facts of an individual case. The arbitrator in this case also found that the question of whether a misrepresentation was material would depend on the facts of the case and may constitute a consideration of what is misrepresented, what is obtained as a result of the misrepresentation, the relationship in monetary and other terms between the misrepresentation and the potential benefit available, and the availability of other provisions to assist the insurer. So although not binding on LAT cases, this case provides a helpful analysis and guidance to follow when applying the section. One key feature of Section 53 is that it's generally applied to one benefit. The language of the section, to take you back, refers to the insured misrepresenting facts with respect to the application for the benefit, not with respect to the application for benefits. Case law has found that what is material with respect to one benefit may not be material with respect to another. I've thrown up the SABO case where the fiscal adjudicator on appeal gave helpful commentary, just citing that it's not difficult to imagine a misrepresentation that's material to the insured's weekly benefits claim, but not material to the claim for medical benefits, which involve a different claims process and serve a different purpose under the SABS. The one exceptional case that I found under the that applied to Section 53 misrepresentation to entire claims is the fiscal decision in Hoey and Vera versus Coachman. In that case, the applicants alleged that Hoey was driving at the time of the accident, but Coachman believed that Vera was the one driving and that Hoey was actually not even present at the scene until after the accident. Vera's license was suspended at the time of the accident, and a Section 31 exclusion would have applied under the circumstances had Vera been upfront that he was driving at the time of the loss. In this case, the adjudicator found that the misrepresentation by the two claimants represented a fundamental misrepresentation. Both insureds intentionally misled Coachman about who was driving and who was in the vehicle. And on the basis of the misrepresentation of these material facts, the arbitrator found that both were not entitled to accident benefits as a whole. Their entire claims were denied. We have not seen any cases like this at the tribunal where someone has been found to be in a legitimate accident but committed a fundamental misrepresentation. Thus, their entire claim was denied. Section 53 often gets applied at the same time as interrelated sections. These include Section 3, where an individual may or may not have been involved in an accident at all. Section 31, where they may not qualify for particular benefits because of an exclusion. And Section 52, claims for overpayment. The wording of Section 52 itself actually includes the term willful misrepresentation. Insurers are permitted to seek repayment of benefits paid as a result of willful misrepresentation or fraud. And normally an insurer has 1 year to seek repayment of benefits which were overpaid. However, if they were paid as a result of willful misrepresentation or fraud, that 1 year limit does not apply. So now we're going to talk about cases at the tribunal involving the application of Section 53. I'm going to go through some examples of the types of cases where the insurer has been successful in applying a Section 53 termination. The first category of cases is a failure to inform the insurer of a return to work. Section 53 is often applied in these types of cases. As I noted previously, the insured's silence or failure to report a return to work has been found to constitute willful misrepresentation. And based on the cases at the LAT, there's no positive obligation on the insurer to ask whether the claimant returned to work before applying this section. When analyzing whether or not a willful misrepresentation has been made, the tribunal has often commented on the insured's pattern of conduct, what they've told assessors, and what they've told the insurer. I wanted to bring up one case in particular, which had a good result for the insurance company and a very negative result for the claimant. And that's the bottom case on this slide, the Aviva and Gurung decision. In that case, the adjudicator actually ordered repayment of all income replacement benefits paid to date, which was over $36,000 worth of benefits. In that case, Aviva obtained surveillance evidence of the claimant working as of approximately 16 months after the accident. The claimant then attended an examination under oath, where she initially lied about her return to work. She later admitted, after being confronted with the surveillance, that not only was she working post-accident, but that she owned the restaurant where she was seen working on surveillance. Aviva brought a LAT application seeking repayment of all income replacement benefits paid to date, and they were successful in that regard. It's important to note that in this case, the applicant did not participate in the proceedings at all. Aviva requested additional income documentation and she did not provide anything. The adjudicator ended up holding that there was no information before her that permitted her to calculate the quantum of repayment of income replacement benefits or the deduction of post-accident income to which Aviva would have been entitled. This information was directly within the power and control of the claimant, and I think that it was telling that the adjudicator relied on her lack of participation and lack of cooperation when she awarded repayment of all benefits. This is something to consider if you do find that your claimant has returned to work and you want to seek repayment if you stop getting cooperation. You're not necessarily limited to the time frame where you have evidence of the individual working. Section 53 has also been applied in other employment scenarios when insureds have provided false information such as a signed statement asserting that they were working or on EI at the time of the accident, where this information was not correct and they otherwise would not have qualified, making up employment, falsifying information on the OCF1 where they otherwise would not have qualified, and as you can see from the bottom case, failure to disclose receipt of EI maternity benefits post-accident, which were found to be deductible benefits. Another category of cases where we see Section 53 applied is where a Section 31 exclusion applies. These cases come up when the insurer pays a benefit for a period of time, but then realizes that an exclusion would have applied and they would not have otherwise had to pay the benefit. The cases we've seen this in where the insured has lied about the status of her driver's license at the time of the accident, saying it wasn't suspended and falsifying documentation to that effect when it was suspended. Failure to disclose that a partner with a poor driving record has moved in order to save on premiums, and providing a false address to get a cheaper insurance premium. In all of those cases, the insurer used Section 31, Section 52, and Section 53 to terminate the benefit and to seek repayment of the benefits paid. Another category where we see Section 53 being applied is that of staged accidents. In these cases, the insurer usually relies on Section 3, that the insured was not in an accident as defined in the SABS, and Section 53, that they made a willful misrepresentation when describing the accident. Arguably, the insurer could simply have relied on Section 3, in that if you're not involved in an accident, you're not entitled to any benefits. It's interesting to note in this case that the onus shifts depending on which section you're relying on. If you're relying on Section 3, the onus is on the claimant to prove that he or she was involved in an accident. If they fail to prove this, they're not entitled to benefits. If you're relying on Section 53, the onus is on the insurer to prove the misrepresentation. Although the onus is different depending on the section upon which the insurer relies, if the insurer is denying the claim on the basis of a staged accident, the claim will generally be handled the same way from a strategic standpoint. I don't have a recommendation one way or another, whether to reference one or both sections when denying a claim. I think that the hearing will ultimately unfold in the same manner. Considerations with respect to other benefits and potentially applying a Section 53 misrepresentation with respect to attendant care. I've included 2 cases below where the insurer had strong concerns regarding the care required and received by the claimant following an accident. The insurer noted discrepancies between the invoices it was receiving and the surveillance evidence that it had collected over time. In these cases, both the claimant and their care providers testified at the hearing, and it does not appear as though Section 53 was applied or argued in either case. In both of these cases, the adjudicators seemed to give the claimants a lot of leeway, accepting their testimony and only disallowing payment for attendant care benefits when it was glaringly obvious that no care was provided on specific days. We found that some of the explanations also defied credibility, so these individuals must have been somewhat convincing in their contention that they required the care that they say they were receiving. In cases with attendant care, it may be advisable strategically to apply the Section 53 termination to a benefit if you've marshaled enough strong evidence that the claimant does not require and is not receiving the care that they say they're receiving, and then defend your case in that fashion. So, what to do if you believe that you have a Section 53 termination that should be applied? The most important thing to do is get that evidence. Quite often, the cases that we see proceeding to the tribunal where Section 53 has applied are cases where the claimant does not defend, does not show up, and stops cooperating. Therefore, the insurer is left to argue its case without the benefit of cross-examination or any further documentation after they have applied the termination. You're going to want to make sure that you use all of the tools available to you to obtain the evidence you need to prove the willful misrepresentation. If you think you're ready to apply a Section 53 termination, things you should consider before you do. Do you have all of the evidence you need? Is there anything else that you can or should be obtaining to strengthen your case at this point? Often it's advisable to get absolutely everything that you think you can from a claimant first before applying the termination, because as I mentioned, once they stop cooperating, you're likely not going to be able to get anything else. You need to think about whether or not you can prove that the applicant was the one that made a willful misrepresentation. One example of this would be going back to those attendant care cases, comparing the invoices received to the surveillance evidence. In that case, if the invoices are coming directly from the attendant care providers, you don't actually have something that the applicant has asserted in terms of what he or she is receiving in care. The way to obtain that evidence in that particular case would be to get a signed statement, have the claimant review the invoices and corroborate that they're accurate, and or do an examination under oath, obtaining that evidence. Do you have enough evidence that shows that your misrepresentation relates to material facts? The tribunal's not going to accept something if they don't believe it relates to a material fact tying to a benefit. And have you sent your notice with reasons? You can't apply Section 53 if you haven't sent the notice. Well, that is the end of my presentation. So I'm just going to take any questions. I see we have a few in the chat box, but if anyone else has any questions, please feel free to submit them at this time. So a couple of the questions were just requests for the presentation materials, that's fine. And then I see one question here which relates to whether or not the insurer has a positive obligation to ask about a return to work before it can apply a Section 53 termination. Based on the case law and the case law referred to in our slides, there's no obligation of the insurer to be making that request. Obviously, it's advisable after an accident. You want to be asking the claimant if he or she has returned to work after a reasonable period of time. And you also want to be asking the same of the employer, because they've got no skin in this game, and they're likely going to be providing you with honest information about a return to work, provided it's an arm's length relationship with respect to employment. So although it's helpful for your purposes to gather that information, it's not necessary that the insurer has reached out and made those requests before it applies a Section 53 termination. If you have the evidence that the insured has made a willful misrepresentation, you can apply that termination right away without sending requests. Reading the next question, when you make a request within the 1 year under Section 52, is there a time limit for when we can pursue the claimant further for repayment? Do we submit a LAT request for repayment if they do not respond, or how do we handle a refusal for payment? There is no time limit under the overpayment section, or a time limit for the insurer to pursue that overpayment. Your only time limit is under Section 52. So you've got the 1 year to seek repayment if it's the insurer's error or an error regarding the payment, and you have an unlimited amount of time if there's been a willful misrepresentation. So I would just say it's advisable to commence a LAT if you have the evidence you need and you want to move forward with it. Handling a refusal for repayment, commence the LAT. There's no reason to wait if you know that they aren't going to repay the benefits. At the end of the day, you may be using this strategically in settlement negotiations to offset any other settlement amount. But otherwise, while there's no time limit to commence a LAT, there's no reason to wait on same. So my recommendation would be, if you're not getting a positive response within 1 to 2 months and within 1 to 2 follow-ups, to issue your LAT application and move forward. Another question, what happens if the insurer gets it wrong? Gotta scroll down. What are some downsides of applying a misrepresentation without gathering the evidence in advance? I haven't seen any decisions where the tribunal has come down on an insurer. Essentially, there are some decisions where the insurer is unsuccessful and the tribunal simply finds that the insurer has not proven its case. And so if you're seeking a repayment of benefits, which is often the time when the insurer is proceeding to the tribunal finds that the repayment is not payable. I think that's basically the only other consequence. I would say if you've terminated a benefit that you were paying on an ongoing basis and the applicant is disputing that termination, there could be a finding that they remain entitled to the benefit. We saw that back in the day at FSCO. One example was someone had returned to work for, let's say, 3 weeks at the 2-year mark after the accident and didn't tell the insurer about that 3-week return to work, which was ultimately not successful. They went back off work again. They found that they couldn't handle it. The FSCO arbitrator found that this was not a willful misrepresentation. The return to work was not lengthy enough and was ultimately unsuccessful. So essentially the benefit just continued to be payable. All right, it looks like we don't have any other questions in the chat. So I'm going to let everyone else know that we do have a couple of upcoming webinars in August. My partner, Lisa Armstrong, is presenting on August 11th, and her presentation is on negotiating tips for adjusters. And my partner, Tim Gillibrand, is presenting on Thursday, August the 26th, and his presentation is on vacancy exclusions on property claims. So if this is of interest to you, we hope that you join us for the coming webinars. I appreciate everyone coming today. And once again, if you would like a copy of any of the slides today, please feel free to shoot me an email. I'd be happy to send them to you. And if you have any colleagues that would benefit from viewing this presentation, please send them to our website. We've recorded the presentation and they can access it there. Thank you everyone so much for attending. We're going to end the presentation now.